Welcome to the first Experts Helping Experts webinar. Many experts, I would say all experts, are expert in certain areas. So we want to create an avenue for you guys to be able to share your knowledge with others and also learn from your fellow experts. Our first webinar will be led by Richard. We're so grateful for him to volunteer for the first one. So just a little bit about Richard before he starts. He's been an expert on JustAnswer for 6 years. He's a licensed attorney, licensed in Texas, and he's been practicing law, business, real estate, and tax laws for over 35 years. Obviously, the topic for why you all here today is to learn a little bit about estate planning, probate, wills, the process, questions that you should be asking yourself about estate planning, and at the end of the webinar, you'll have an opportunity to ask questions to Richard directly. During the webinar, if you have any questions about what he's talking about or anything else, on your GoToWebinar widget, there is a question view where you can enter in your questions. So you can feel free to submit your questions at any time, and then during the Q&A, we'll pick the questions and then go through them. So for today, the agenda will be, we'll start off with how estate planning works, 10 questions that you should be asking yourself, some important estate planning documents, and then Richard will cover steps to get started and what you should do next. Also, for example, if you have relatives or family members that need to know about estate planning or need to do estate planning, then how to get started for them. And then, like I said, we'll do Q&A at the end. And with that in mind, I'll hand it off to Richard to get started.
Good afternoon. How are you guys? Well, I'm happy to be here and happy to help. Basically, when I get started with these, what I like to ask people is, one is, do they have any estate planning documents in place right this minute? And if they still have their parents alive, do their parents have estate planning documents in place? And if they do you know where they are? So that if they were to die, you would know how to access these documents, so you would know what to do. It's an amazing concept to me that this is an issue that faces everybody eventually, and it's far easier to deal with everything going up front than it is to deal with trying to put the toothpaste back in the tubes after somebody has died. And so the real question for everybody is that if you were to die or your parents were to die right this second, what happens? Are you in good shape? And so my goal is to at least lay out the groundwork for you so that you know what you need. It's not an overwhelming process. It seems an overwhelming process, and so many people don't do it because it never rises to the top of their pile. We have the basic idea of an estate plan is to establish what's going to happen when you die. It's important to realize that if you don't have these documents in place, the state has them in place for you. So if you were to die or your parents are to die and they have no wills, then the state has a process to who gets your money and who takes care of minor children. And typically people want to direct what happens to them as opposed to the state. They have minor children they need to deal with, they have money they need to deal with, and so whether you're rich or you're poor, everybody should have basic plans in place. And not only do they need the documents in place, but then you need to structure your assets so that they go through the documents that you intend to do. And we'll get to that in a little bit, but what happens a lot of times is that you'll set up all these documents, and then you don't take the next step to make sure that your assets are titled such that they go through the proper documents. When you don't have a will or a living trust or anything in place and you were to die, what happens is you're deemed to die intestate. And so each state has a process called the intestate succession rules, and it's all related parties, and they have a priority scheme as to who gets your money and how much of it. These are typical questions. I probably get 10 or 15 questions a day on estate planning, some before people die and some people after they die. This first one is a mother dies without a will. The grandfather had previously gifted money. What happens? Is the property deeded, classified as intestate? And do the sister and have any claim to the property? And the question is, if you transfer stuff before you die, those transfers are valid then. And your estate plan only covers the documents that you own as of the date you die. So if you transfer stuff before you die, you make gifts of it or whatever, that's not in your will. So, relatives have no claim for that. Now, what happens a lot of times is if those transfers take place very close to death, or under sort of funny conditions, whereas they have a plan in place and all of a sudden somebody steps in, and they convince the person that's dying to change something in their will or to transfer property so it's not covered by the will, you have grounds to contest those. There's like 4 or 5, 6 grounds to contest anything that happens before death or contest a will, and that would be that you lacked the requisite mental capacity, that there was duress, there was coercion, there was a mistake, or there was undue influence, or was just outright fraud. So if you can prove any of those happen, and the closer to death and the more kind of sick the person is, the easier time that you have to establish that. The next question involved a living trust. A living trust is designed basically to avoid probate. The idea, most states, you don't need a living trust. But the idea is that you do a living trust, transfer all your assets to the living trust, and then it controls what happens at your death because your estate has no assets because they're owned by the trust. And you can change those at any time. Those are not filed anywhere prior to death. I mean, their copies are given to accountants and to bankers and things like that need to transfer the assets and the accounts, but they are not filed anywhere. And then the last question, which is just an example, is my first cousin passed away. He had paperwork in his possession for a durable power of attorney for health care and a durable power of attorney for financial management. As a next of kin, will have access to his information or his estate? And the answer to that is no. And we'll get into this a little bit later in terms of estate planning documents, but there are estate planning documents to deal with before you die and estate planning documents to deal with after you die.